Okay, I'm going to go ahead and get started here. So I want to
Okay.
say good evening to everyone and welcome to our webinar, Legal Help, Tenants and Landlord Issues. John is joining us tonight at the Champaign Public Library. My name is Kat Purcell. I'm a library associate here, and I want to thank you all for joining. To stay up with the latest library news and updates, we invite you to visit our website, champaign.org, where you can always follow us on social media. Moving on to a couple of Zoom features. At the top of the screen, if you're on a phone or tablet, or the bottom of the screen, if you are on a desktop, you might find available to you during this webinar some icons. And you have the option to control your sound on the furthest left-hand side. And then moving to the right, you can control the chat, which gives you the option to chat in a question if you have one. You can also raise your hand if you have that ability and you'd prefer to use that to ask questions. We will be doing our webinar Q&A style tonight. So if you have questions, feel free to ask as we go along, and John will stop and ask it, or if I notice it, I'll let him know we've got a question. So if you see the chat box, you can choose to ask the question to everyone in the webinar or to panelists only, and you can choose to be anonymous if you would like to ask your question without having any kind of a name attached to it. So if you'd like to raise your hand, and I can unmute you and we can speak and we'll ask your question. Please remember that this webinar is being recorded, so be mindful of that. And I will try not to use any names for privacy reasons. And with that, I'm going to go ahead and turn it over to you, John, and you can take us off on tenant and landlord issues.
Thank you, Kat. Thanks. So my name is John Roska. I'm a lawyer at Land and Lincoln Legal Aid in Champaign. I've worked at Land and Lincoln since 1983, and I do mostly landlord-tenant cases defending tenants, and I do collection works defending people who are being sued in small claims and other kinds of cases. So tonight I'm going to talk about landlord-tenant issues, basically from beginning to end. So I'm going to kind of divide that up into the beginning, the middle, and the end, and talk about a couple of things at each point along that way. This is going to be from the tenant's point of view, because I think that's tenants are the ones who have the least access to legal help and lawyers. So that's how I'm going to be pitching it. Landlords who might want to watch this or participate have to understand it's from the tenant's point of view, but that from that point of view, it'll also be helpful too, because it'll be about the general law of landlord-tenant. Before I get into the three things, the beginning, middle, and end part, I just wanted to cover a couple of things ahead of time. Four of those things. First of all, the moratorium, the eviction moratorium has expired. So it is over. There was a moratorium to protect tenants during the COVID pandemic. And those rules, those processes, those tenant protections have expired as they apply to eviction cases in court. So we're back to normal in eviction cases in court. Secondly, I guess the one thing I want to say about landlord-tenant cases, my general word of advice is get it in writing. If you're trying to get a repair or get something that the landlord to do something, put it in writing, and so that they know and have it clear. And that if you think there's a promise about the landlord's going to do something, get it in writing so that it's down in black and white and enforceable. So in general, get it in writing, whether that means getting it in writing from the landlord or put it in the writing to the landlord so that they know. The writing is important for a third reason, about notice. Throughout this presentation, you'll hear notice mentioned quite frequently. Actual written notice or giving notice or notifications. And notice is an essential element in the legal system because it's the basic of due process, that the people have notice of what's happening to them and an opportunity to respond and participate and know what's going on. And finally, in all landlord-tenant issues, the one way to avoid problems is to pay your rent, is to stay current on the rent, to pay it regularly, in full, and on time. Tenants who pay rent in full on time will avoid most of the problems that we'll address tonight. Landlords will put up with a lot with tenants who are current on the rent and good rent payers. So that's the key to avoiding most problems, is trying to stay current on the rent. Okay, so I'm going to cover the beginning of the landlord-tenant relationship, the middle, and the end, and a couple of things about each stage along the way. So at the beginning, we're talking about leases, entering into leases, what leases do, how you use a lease, and then we'll talk a little bit about deposits too. That's all at the beginning of the lease. In the middle, we'll talk about getting repairs done while you're living there, and your right of privacy while you're living there. So that'll be during the lease term after you've moved in. At the end, we'll be talking about moving out, either voluntarily, meaning that you as the tenant want to move out, your lease is expired, and you want to move out, or involuntarily, the landlord wants to make you move, and that's when we'll talk about eviction. Okay, so going back to the beginning, the lease. The lease is the agreement between the landlord and the tenant that covers the terms of the tenant living there. So ideally, it's in writing, but it doesn't have to be. Oral leases, unwritten leases are valid and enforceable. They're not as good as written leases because they're less sure and certain and clear, but they are valid and enforceable. So a lease doesn't have to be in writing. The lease is a contract. Legally, it's the contract between the landlord and the tenant. And like any contract, it contains the essential terms of the contract. For the lease in the landlord-tenant relationship, the most important terms are the ones relating to money. How much is the rent going to be? How much is the deposit? But also, and this is an increasingly a feature in leases, how much are the fees and charges going to be? In particular, are there going to be charges for utilities? I see that much more commonly now in leases, that in addition to the monthly rent, there are monthly charges for utilities, usually things like water and sewer or trash, usually not for electricity and gas, but like I said, for water and sewer, because the landlord will often leave that main bill in their name and divide the bill up between the tenants. And so it's really important in leases that the tenants understand what they're going to be charged. If there's going to be utility charges, how much is that going to be? Is it going to be a flat monthly fee? I've seen fees like $39 a month, $49 a month, or is the fee going to vary according to some formula that the landlord makes to divide up a utility bill? But it's very important to understand what those fees are going to be, because in those situations where there are fees, the monthly rent is going to be more, and sometimes significantly more, than just the monthly rent. So for example, the lease may say that the rent is $650 a month. You sign the lease thinking it's just going to be that, and you find out it's another $50, $75 or more for additional monthly fees for trash, whatever. Landlords are very adept at nickel and diming with fees. And so it's important that those fees be disclosed in the lease clearly, and it's important that the tenant understand them. If they're not disclosed in the lease clearly, then the landlord can't charge them. That's the whole idea about a lease, is that it explains to each side what the other is supposed to do. And if the lease doesn't clearly disclose a charge or an obligation or some kind of a rule, then it can't be enforced. And it's not unusual for a lease to say that the tenant is going to be charged for water and sewer extra, but it doesn't say how that extra amount is going to be calculated. So if it's not clearly disclosed so that the tenant can know in advance what it's going to be, it's not enforceable. And that goes to any kind of a term. So make sure that the terms are clear, make sure that they're understood, and if they're not clearly disclosed in the lease, then they're not enforceable.
John, I had a question real quick from
Sure.
someone. So is there anything before you set up a lease that like a landlord isn't allowed to ask?
Well, I guess in terms of screening tenants, they obviously can't discriminate illegally. So they can't discriminate on the basis of race, sex, sexual orientation. There's a whole list of what's prohibited in terms of discrimination. So they can't do that. And they can't discriminate based on family status. So they can't say, we're not going to rent to you because you have kids. They can say who's going to be living there. And I think that they can't ask about disabilities. Are you disabled? So they can't ask about that. But otherwise, it's just what they can't do, which is illegally discriminate. If there's specific things that people have questions about, can they ask about this in particular, that in particular, I'll be happy to take them individually. So please chime in if there are those. Okay, so again, and pop in anytime with questions. So that kind of covers leases. About deposits, there's no limit on the amount of the deposit, although typically it's 1 month's rent. The only limit on the amount of the deposit is in mobile home parks. For some reason, the law that applies to mobile home parks says that the deposit can't be more than 1 month's rent. I don't typically see deposits that are more than that, but technically there's no limit on what the amount of the deposit is. Okay, so that's kind of figuring or covering the beginning of the lease experience, entering into the lease and moving in. So in the middle of the lease, then we're talking about living there, having moved in. And what I want to try to cover and touch upon is two things: the right to get repairs and how you get repairs done by the landlord, and the tenant's right of privacy. As far as repairs go, that's where putting it in writing is essential. Okay, so there's two ways to get repairs. And one, the first is to put it in writing and ask the landlord to make repairs. Doesn't have to be fancy, doesn't have to be formal. I always tell tenants just to make a list, 1, 2, 3, 4, until you're done, your wish list of what you want the landlord to fix or do. And make sure that you put it in writing, make sure you date it, and make sure that you then make a copy for your records so that you have a copy of what you gave the landlord. That way you have a paper trail. So, and that's essential, because if you don't put it in writing, the landlord will typically say, well, you never told me that the toilet needed to be fixed. If you've got it in writing, and you've got your copy, then you can say, hey, look, on November 2nd, I gave you this list that said fix the toilet. Now, in delivering that to the landlord, it's up to you. There's no magic way to deliver it. You can hand it to the landlord. You can put it in, send it by email, doing text. I prefer the old-fashioned written way, so that you have the written paper trail, but email is okay. If you're going to do it by paper, you can send it by regular mail. You can also send it by certified mail. I guess that's one way to have proof that they actually got it if they signed for it, but it's not necessary to do that. And in many ways, sending things by certified mail is no guarantee that they're going to get it if they refuse it. So you can do it that way, but it's not required. Emails that, with a proof that they read it or received it, that's just as good too. Okay, so put it in writing. If the landlord won't respond to that, they don't respond to that, then the second thing that tenants can do, but this is only where there's a building inspector, is to have the building inspector come and do an inspection. So Champaign, Urbana, Danville, for example, have inspectors who will come out and do inspections, and they will enforce the building code. Unfortunately, however, outside of towns like that, if you are in, say, I guess something like Villa Grove or St. Joe or Longview or Royal or just plain out in the boondocks, then you don't have a building inspector that you can go to. But if there is a building inspector, then they are the ones that can probably be most effective in making the landlord make repairs. I know, for example, we are lucky in Champaign and Urbana that we have excellent building inspectors who will go out promptly upon the request and make a inspection, complete an inspection, complete a written inspection report that goes to the landlord and gives the landlord 30 days to correct any code violations. So, and then they will kind of hound the landlord to make sure that those code violations get corrected. They will do re-inspections after 30 days. And if the code violations are not corrected, then eventually they can start fining the landlord for not making the repairs. But where there's an inspector, in addition to making the written request on your own, then ask the inspector to do an inspection. Sometimes you may have to make a written request. Sometimes you might have to jump through some hoops to make sure that they complete the inspection, but try to make sure that the inspector comes out, completes an inspection, actually issues a written report that goes to the landlord and says to the landlord what they have to fix and how soon they have to fix it. Okay, so if the landlord doesn't make the repairs, and if for some reason an inspector is not available or is not effective in making the landlord do repairs, then Illinois has a limited law that allows the tenant to repair and deduct. It's kind of technical. You have to follow it closely to make sure that you jump through the hoops correctly. But if you follow those procedures by giving written notice, giving the landlord, I think it's 14 days to make repairs. And then if the landlord doesn't make the repairs after the written request, the tenant can deduct up to 1/2 of their monthly rent, a maximum of $500 to make repair. So as I said, the right to repair and deduct is limited. It's up to a maximum of $500. So that means if your rent is $1,000, you can deduct half of the month's rent to make the repairs. So that's a very limited right to repair. If your rent's $650, then the limit is $325 on what the tenant can spend on repairs. And that's after making the written request and the landlord hasn't responded. The tenant must pay somebody else to make the repairs. The tenant can't make the repairs themselves. So they have to, the idea is that the tenant pays a regular repairman to do the repairs and then has the proof, the evidence, the receipts that that work was done, and then can deduct that from the rent. So what that does when the tenant follows the repair and deduct procedures is it protects the tenant if the landlord says, well, you didn't pay your rent in full that month, so I'm going to sue you or try to evict you for non-payment of rent. If the tenant has followed the procedures correctly, allowing them to repair and deduct, then if it ends up in court, the tenant has a defense to the eviction by proving that they followed the procedures correctly that permitted them to deduct that amount from the rent. Again, it's up to 1/2 of the monthly rent with a maximum of $500. Okay, so that's repairs, trying to do repairs. The other thing I wanted to cover during the lease and during the landlord to tenant relationship was the tenant's right of privacy. In all leases, whether they're oral or in writing, whether it's in the written lease or not, the law implies what's called the right of quiet enjoyment, basically privacy. That the tenant has the right to enjoy their apartments, their premises, and be peaceful and tranquil and not be bothered by others or anything. They have the right of peaceful enjoyment, and whatever interferes with that unreasonably is a violation of the lease. The particular concerns a lot of tenants have is the landlord coming in unannounced, just barging in. So that is a violation of that right of quiet enjoyment. The written lease should address that. It should say when what right the landlord has. A good lease will say that the landlord has to give, say, 24 or 48-hour advance notice of any entry for routine repairs. Now, usually it will say that the landlord doesn't have to give any notice for emergencies. Obviously, if there's a leak or a busted pipe that needs immediate attention, that's when 24 or 48 hours advance notice doesn't make any sense. And in those situations, in emergencies, the landlord's immediate entry is reasonable. So the lease should spell that out. If it doesn't, then I guess it's a question of what's reasonable. But just the open access by the landlord is not reasonable. The fact that the landlord owns the apartment or the house doesn't give them the right to enter at any time. The lease restricts the landlord's right to do that because it gives the tenant the right of quiet enjoyment, which means that they don't have to let the landlord in, and they can refuse to let the landlord in. So that's often an issue. Now, one thing I guess I should point out is that Urbana has an ordinance that specifically addresses that. That requires landlords to give advance notice if they're going to make repairs or if they're going to show the apartment to other prospective tenants. So Urbana is the one place around here that does have a landlord-tenant ordinance that covers things like that and provides additional protections for the tenant. Okay, so that's the middle of the landlord-tenant relationship, covering repairs and the right of privacy. So finally, I'll move on to the end of the lease relationship and moving out. And the two ways of moving out that I'm going to address is the tenant voluntarily leaving at the end of the lease, or maybe even in the middle of the lease, or the second way is the tenant involuntarily being required to leave by the landlord, which is an eviction. And we'll talk about evictions in a little bit more detail. So at the expiration of the lease, when the lease is up, the tenant, unless there's some kind of a renewal, the tenant should move out before the lease expires. It's always good to give notice. Urbana requires that the landlord or the tenant give 30 days notice before the lease expires to let the other side know that they're not going to renew the lease. So in Urbana, it's clear that even if the lease doesn't address that either side has to say, I'm not renewing the lease 30 days ahead of time. So when tenants move out, my advice is to completely clean the apartments the general idea is that it's restored to the same condition as when you moved in. Reasonable wear and tear accepted. So what reasonable wear and tear is, a few nail holes on the wall, that's reasonable wear and tear. Some dinginess in the carpets, that's reasonable wear and tear. But beyond that is what may make the tenant liable for repairs. So to avoid any claims of damage, I always advise tenants to completely move out of the place. Don't leave anything behind that the landlord has to remove or haul off, because landlords will commonly charge for that, or they may think that the tenant hasn't moved out because their stuff is still there, or even some small part of their stuff is there, and that therefore the tenant has to be evicted before the landlord can go back in and take control of the apartment. Some very cautious landlords will not touch a tenant's property without an eviction order, so that anything that gets left behind means that they go and get an eviction order to remove a mattress that's been left behind, or a dresser or something like that. So if you don't want it, make sure you remove it. Otherwise, there's a risk that the landlord will think that you haven't moved out and file an eviction case based on that. And then take pictures so that you have your proof of what the condition of the apartment was when you moved out. Pictures are your best protection against the landlord claiming that you trashed the place or left it in bad condition. When the landlord has pictures and the tenant doesn't, the landlord usually wins. If the landlord has pictures and the tenant has pictures, then it's a fair fight. And so that's why tenants should always take pictures when they move out, showing that everything's been moved out, showing that the place was cleaned, and that's their best protection. Make sure that the pictures show that the stove and the refrigerator were clean. Those are the two things that landlords often claim are left the dirtiest: the stove, the oven, the refrigerator. So get good pictures of that, showing that was empty and clean. And then make sure you hang on to the pictures, because you may need them months after you've moved out if the landlord gets around to filing some kind of a damage claim, or claiming that, for some reason that you owe money because of damages. You may need them months from now, so make sure that you hang on to them. Make sure that when you take them, that they're good and clear. I see a lot of really fuzzy, out of focus pictures that aren't helpful at all. It's hard to tell what they're of or what they're supposed to show. So make sure that they're good, sharp, clear pictures and that you hang on to them. Moving out in the middle of the lease is not, the tenant does not have the right to do that. As I said before, the lease is a contract, so it binds the tenant to that term. So if the lease is for 12 months, it's a promise to pay rent for 12 months. And if the tenant moves out in the middle of that, the landlord can continue to seek rent from the tenant until the place is either re-rented or until the lease has expired. So if tenant moves out in month 6, leaving 6 months unpaid, and the landlord is unable to re-rent it in those last 6 months, the tenant is on the hook for 6 months rent that they weren't living there, because the contract says that the tenant has promised to pay rent for that full 12 months. Now, moving out in the middle of the lease is subject to negotiation. In fact, it may be in the lease about how you can get out of the lease. I have seen leases that say, yes, you can get out of the lease as long as you pay 2 months rent penalty or more. But it could be in the lease, or it could be subject to negotiation. If you're going to negotiate some kind of a move-out agreement that lets you out of the lease, again, and especially get it in writing. An oral promise from the landlord that they're going to let you out of the lease is not reliable. Get it in writing so that you have something you can enforce if they change their mind later on and claim your rent.
Hi, John. I had an advanced question on that topic, actually. And I would like to, before I get into it, I want to remind my attendees that you can ask a question anytime. John is willing to answer them. If you want to raise your hand, we can unmute you. And if you would like to chat in the box and remain anonymous, you can set that option as well. But I did have a question specifically for someone who is involved in a sorority lease agreement, and they needed to leave early because they were transferring schools, and they were able to find another replacement for their room holding, but the sorority is still requiring them to continue paying for their room and board in that sorority room. Is that something that's permissible? What should they do about that, or what options do they have?
Well, first look to see what the lease says. And sororities may be a little bit different. I'm not familiar with them. They may have kind of idiosyncratic lease terms or contracts. So I don't know about that. But typically, a lease would may say what the penalty is. But in general, if the tenant moves out and is their space is replaced with somebody else who's paying rent, then the landlord is made whole, and there's the original tenant should have no further liability. Now, if the landlord replaces the original tenant with somebody at a lower rate of rent, sometimes they have to do that just to kind of get something, then the original tenant's liable for the difference between the original amount and maybe the reduced amount that the landlord had to accept to get somebody in there. But no, the landlord's not. It's not legal for the landlord to kind of double dip and get double rent or two rent payments for the same unit from two different tenants for basically renting that unit. I hope that answers it.
Yeah, I think so. Like I said, this was a question submitted in advance, so I'm not sure in the details of that, but I appreciate your response all the same.
For sure that if in the conventional landlord-tenant lease, if say for example, the tenant moves out after 6 months and they find, or the landlord finds, somebody else to move into that apartment for the remaining 6 months at the same rent that the original tenant was paying, so that the landlord incurs no financial loss, then the landlord cannot charge the tenant who moved out for the final 6 months of the contract because they simply moved out. The landlord got paid for those 6 months. They can't get paid twice for those 6 months. Okay, so again, if that doesn't answer the question, feel free to follow up. But moving out is negotiable, so get it in writing. Okay, so involuntarily moving out, talking about evictions then, okay? And so the one thing to know about evictions is that the tenant cannot be evicted without a court order signed by a judge, okay? And that means there's got to be a court case, okay? So the two steps in the eviction process are a notice from the landlord and a court case. So those are the two main steps: notice and a court case. The court case, the aim of the court case is to get an eviction order signed by a judge, which then permits the landlord to remove the tenant from the apartment. But until those processes are complete, the tenant can stay where they are and cannot be evicted. So kind of the corollary of the rule that the tenant can't be evicted without a court order is that it's illegal for the landlord to evict the tenant or to try to evict the tenant or make the tenant leave without a court order. Okay, that's an illegal self-help eviction if they try to evict the tenant without a court order from a judge. Okay, so the two steps: notice, court case. The notice is something that comes from the landlord. It's not an order. It's not from the judge. It's not from the court system. It's just something that the landlord gives the tenant saying, tenant, I want you to leave for the following reason. So again, it's a notice. We kind of talked about how important notice is. That's why the first step in an eviction case is notice. So it's legally it's called a termination notice. And they come in three basic forms: a 5-day notice, a 10-day notice, and a 30-day notice. 5-day notice is the most common. It's for non-payment of rent. 10-day notice is for other kind of lease violations, loud parties, too many people in the apartment, unauthorized people living there, disturbances, whatever. So it's other non-monetary breaches of the lease. A 30-day notice is used when there's a month-to-month lease to terminate that month-to-month lease. And so a 30-day notice can be given when there's a month-to-month lease for any reason at all, just because one side decides they want to terminate the month-to-month lease. And I'll get back to month-to-month leases before we end to cover them a little bit more specifically. But the 5-day notice is for non-payment of rent. It says, tenant, you owe this amount of money. You have 5 days to pay it. If you pay within 5 days of receiving this notice, that stops the eviction and it cannot go any further. So the 5-day notice is the one notice that gives what's called the opportunity to cure. It gives the tenant the chance to pay the money that's owed and stop the eviction. If the tenant pays what's owed within 5 days, then that's it. The landlord's cured, the landlord's caught back up, and the landlord can't file an eviction case. I guess the technicalities to cover are that the notice has to be personally served on the tenant. That means it's got to be handed to them, just like a summons does for a court case. You got to tag the tenant personally, in person, with the notice. That goes for a 5-day notice, then 10-day notice, 30-day notice. You got to hand it to them. The landlord can also serve it by certified mail so that the tenant signs for it. But like we kind of mentioned before, that's an unreliable way of making sure they get it. So most landlords serve it personally. What's not proper is posting it, taping it to the door, slipping it under the door, coming in and leaving it on the kitchen table. Those kind of service is not what the law requires. It's got to be handed to the tenant. So if the landlord posts it, then that's a defense to the eviction. The landlord didn't follow the eviction procedures correctly, and the case can be dismissed if it goes to court. Okay, so that's a 5-day notice. When the 5 days are counted starting with the day after the tenant receives it. So you don't count the day they were served, you count the following 5 days. So, for example, if the landlord serves a 5-day notice today, November 2nd, we don't count the 2nd. We count the 3rd, 4th, 5th, 6th, 7th. So the 7th of November would be the 5th day after service. That's the last day for the tenant to pay their rent. If they have not paid in full on that 5th day, which in our example would be the 7th of November, then the landlord can file the eviction case on November 8th. They've given 5 complete days after service for the tenant to pay the rent. And if the tenant hasn't, then the second step of filing the court case and be done. Okay. If the landlord files prematurely, meaning before the 5 days are up, then the case can be dismissed. That's a defense to an eviction. Okay. So, personal service of the notice and the not counting the day of service as one of the days in the notice are important things to understand. A 10-day notice is, as I said, for other lease violations. It does not give the tenant a right to cure. It simply says, tenant, you violated your lease. I'm terminating it with this 10-day notice. After 10 days, if you're not out, then I'm going to court. Same thing about counting the days and waiting before the case is filed. Okay. 30-day notice, let me cover that, is for a month-to-month tenancy. Those typically occur in an oral lease where you don't have a writing saying that it's for a year, or when a written lease expires. So for example, if the lease expired July 31st, as typically happens around Champaign, Urbana, then starting in August, if the tenant remains there, usually that begins a month-to-month. It doesn't extend the lease for another year unless there is actually a written lease signed. But if it just expires and nothing is done, and the tenant continues to live there and the landlord continues to accept rent, just like always, then that's a month-to-month lease. Same general terms or the same terms of the lease on a month-to-month basis without that 1 year of the original lease, written lease. So as I mentioned about a month-to-month lease, it's good for a month at a time. Either side can say, I've decided I want to end it by giving a 30-day notice. So a 30-day notice is used to terminate a month-to-month lease. The thing to know about a 30-day notice is it's got to give a full rent cycle before the landlord can file an eviction case. That usually means a full calendar month, because usually rent is due the first of the month, and so the landlord has to give a full rent cycle before, with those 30 days. So for example, if the rent is due the first and the landlord wants to give a 30-day notice to terminate a month-to-month lease, or the tenant, if they gave that notice today, November 2nd, that notice would not give 30 days before the next rent payment is due, December 1st. So that 30-day notice, what says it's a 30-day notice, would only be good for starting an eviction case January 1, because that would have, by January 1, the tenant would have gotten a full rent cycle, a full calendar month before they had to move out. That's the general idea in a month-to-month lease. It's a month at a time, not just 30 days at a time, but a full rent cycle at a time. Tenant pays 1 month's rent, they get to live there for a month. If they pay the next month's rent, then they get to live there for the month. So 30-day notice has got to give a full rent cycle before an eviction case could be filed. Okay. So 5, 10, 30-day notice, that's the first step in the eviction process. Second step is filing the eviction case. When that happens, then the tenant gets served with a copy of the eviction complaint and the summons. The summons will tell the tenant the date, time, and location of the first court date. And at that first court date, it is not the trial. It is simply what's called the first appearance. It's to let the judge know, do you want a trial? If you don't, if you're agreeing to move out, or if you've got an agreement to dismiss the case or get caught up in the rent or whatever, at the first appearance is when you tell that to the judge. But the summons is not an order to come to court. It's basically an invitation to come to court. If the tenant who's getting sued doesn't come to court. It's not like they go to jail, like some people think, oh, if I don't show up, I'm going to go to jail. No, if they just decline the invitation to appear, then they basically lose the case by default. They haven't shown up to contest the case. The landlord gets what they want if the tenant has been served. I mean, that's how it works basically in any kind of civil case involving a summons. If the tenant or if the defendant, the person being sued, doesn't respond on the date specified or within the time specified, usually 30 days, then the defendant loses because they haven't contested the case. Okay, so in evictions, the first court date will be a specific date for the tenant to show up and say, I want a trial, or we've got an agreement, I'll be out in 10 days or whatever. So if the tenant asks for a trial at the first appearance, the trial will be scheduled for some later date. In Champaign County, the routine is that first appearances are on Monday, trials are almost always on the following Thursday morning at 9 o'clock. So that's as we say, the rocket docket in Champaign County. Things go really fast. In other counties, they may not go as fast. For example, in Douglas County, the first appearance could be anytime, and the trial may be weeks later. So it varies county to county. So you kind of, you have to know what your county's procedure is. And the way you can find that out is by calling the circuit clerk's office saying, hey, I've got this first appearance. Typically, if I ask for a trial, when will trials be scheduled? Now, we know for sure what the schedule in Champaign County is going to be. Other counties, it's a little bit less certain, but generally, they will be able to tell you that the trial will be within 5 to 10 days of the first appearance. For example, in Danville, trials are usually sometimes later that week or the following week. Could be more than that, but typically within 5 to 10 days. Okay, so the trial is where each side puts on its evidence. The landlord has to prove their case, so it's their obligation to present the evidence that shows that they have followed the procedures correctly. That means they got to prove these basic things at an eviction trial: that there was a lease, that there was a breach, that there was notice, proper form and properly delivered, and that they then filed their court case after the time in the notice expired. Those are the basic, what lawyers call elements of the landlord's case in an eviction case. If they can prove those things, then the burden will probably shift to the tenant to prove what their defenses are, why they can't be evicted. If the landlord doesn't prove each of those elements, then they should lose. If, for example, they don't prove any notice, or they don't prove proper service of the notice, or they don't, or the evidence shows that they didn't wait the full period of time given in notice before filing their case, those are defenses that would stop the landlord from winning the case. I guess the reality in eviction court is that tenants don't really win, landlords lose because they did it wrong or that they messed up some way. It's less common for the tenant to somehow prove, no, I didn't violate the lease, or I don't owe any rent. It's the landlord simply hasn't proven that they have the right to evict the tenant. Other defenses to an eviction case are, in fact, that the tenant doesn't owe rent, or the tenant tried to pay the rent within the 5 days of the notice. That's called tendering the rent within 5 days. If the tenant tenders the rent in the full amount demanded in the notice within 5 days of getting the notice, and the landlord refuses it, that's a defense to the eviction. they have to actually tender it, which basically means having the money physically in your hand and trying to put it in the landlord's hand. Just saying, I've got it, you want it, is not good enough. You have to mail it to the landlord and they mail it back. You have to have it in your hand and they say, no, I don't want it. And they actually give it back to you. But you got to actually try to, deliver the money to the landlord to have a tender defense. The fact that the landlord rejects it does not mean that the rent's not owed. It gives you a defense to the eviction, but the tenant owes rent for any time they occupy the premises, whether the landlord has accepted rent or not. Okay, so then that's the eviction process. Other defenses could be defective conditions. And the way that works are that the tenant proves that there were defective conditions in the apartment that the landlord knew about and didn't repair. And the end result of those defective conditions is that it makes the place worth less than the agreed upon rent. For example, the rent in the lease is $750 a month. There were defects, say, no heat for the month in winter. The utilities were out for a month, or other things like that. But they have to be severe defects that really impair the right of quiet enjoyment. Little things like a broken window, a broken air conditioner in the winter, those are not going to affect the tenant's comfort in a severe way. So they're probably not going to be taken terribly seriously by a judge. The defective conditions as a defense to an eviction is not your ordinary defense. It's rare. And so it's something that judges do not see very often. And they generally set a pretty high bar for what the defective conditions are going to be to give any kind of reduction in the rent. But if the tenant can prove that there were these defective conditions that reduce the value from, say, $750 to $500 a month, and they've paid $750 a month for all the months that those conditions existed, but they didn't pay the last couple of months. If you can show that what the tenant has paid would have paid the rent in full if the rent was reduced to $500 a month for those months, then the end result is that the tenant does not owe rent as the result of those defective conditions, and the landlord can't evict for non-payment of rent. It's a uphill climb. There's all sorts of pitfalls. It's not really a do-it-yourself thing. That's when you really need a lawyer to do that. But it is a possible defense to an eviction case. Okay, I think that kind of covers everything I had planned to. So I'll be happy to answer any other questions.
Okay, I'll go ahead and unmute and stop video. And yeah, just as a reminder, this is your chance to ask some questions. So you can raise your hand there at the bottom panel if you'd like to ask with a voice, and I'll unmute you. If you'd like to use the chat box, you're more than welcome to pop a question in there, and we can get to your question. I want to take the time while we're waiting to see if we get questions to thank you, John. That was a great webinar. It definitely enlightened a lot of stuff to me, and I'm very lucky that I don't have to rent right now. So, but it's always good to have that information, and I really appreciate you going through all those different steps of the process from start to finish.
Great, thank you. Doesn't look like there's any questions. I guess we're going to finish up. I'll just say again, get it in writing, and you can't be evicted without a court order.
Yeah, that sounds like the best key there, getting it in writing. I'm going to put up our little panel as we exit out here. So I just want to remind our viewers here that this is an ongoing series, and so we'll have our next one coming up in December. Is for now the first Tuesdays every month. If you have any questions that you think of later, please feel free to let us know here at the library. I can double check with John later if we've got some questions, but you can always book a librarian with us to meet with a librarian one-on-one. You can always chat us live from the homepage of champaign.org. And you can always send us an email at librarian@champaign.org. Today was the tenant and landlord issues webinar, and the next one will be December 7th at 7 p.m., which is what to do when facing debt. So I hope you can join us for that, viewers. And thank you again, John, for everything you went over. We really appreciate it.
You're very welcome. I love the library.
Thanks. Well, take care and have a good evening. All right.
Thanks. Bye.